evening. I hope you all enjoyed the riveting general meeting. This debate is entitled, "This House Supports the Right to be Forgotten." It's kindly sponsored by Mendeley. Their co-founder Jan will just say a few words before we begin the debate. Jan, wherever you are. There you are. Hello, please do say words.
Thanks, it's a pleasure for me to be here, in particular because I've never participated in any of these debates, being German myself. Platform for academics. So we have a suite of tools which researchers and scientists in this world use to organize their knowledge and organize their information and collaborate with each other. And what we want to do is we want to make, of course, the experience for these researchers and scientists as good as possible. One example is, for example, that we look at what do researchers organize in their libraries. We anonymize that information, aggregate it in the cloud, and run, for example, recommendation algorithms that help those scientists and researchers find information in a better way. Now, of course, this has some implications, because the question then is, well, how comfortable do scientists feel if there's an automated mechanism that aggregates information on a large scale? If you look on the one hand, the opportunity that we have, if you were able to connect the 10, 15, 20 million scientists in this world with each other based on the knowledge that they have in their computers, in their libraries, in their databases, imagine, right? Stuff that they don't even know, but we can figure out via algorithms, by aggregating it, surfacing that, and connecting people and letting them know what they should be reading in terms of publications. On the other hand, scientists are afraid of being scooped, right? Scientific publishing and scientific research is a very competitive field where you cannot share information with other groups, of course, that work on similar topics, because there's a lot of competition for grant funding, for government money. So the question really is, how do we balance the need to support people in being more productive, saving time, in particular in the field of science, and it's a field where all of you, I think, have a strong feeling for that we should support this, against the balance of, well, privacy, data protection, something that we, of course, care very deeply about. Now, Mendeley as a company, we've always been very transparent about how the system works. We've always had the community challenge us. We've had very good experiences. But I think it's in our kind of mission and in our kind of attitude to continue this discussion, in particular with some of the brightest minds that we have in the country, and I hope that this discussion here will contribute to that, and that is why we sponsor this debate. Thank you.
Thank you very much, Jan. Okay, so a quick rundown of how this debate is going to go, in case you're unfamiliar with our format. What will happen is the first proposition speaker will stand up. They'll give a speech of about 8 minutes in length. They'll be notified by our wonderfully cheerful Vice President Nick when they have 1 minute remaining, and then when they ought to bring their speech to a close, Nick will smile at them happily and say, "Hello, would you like to bring your speech to a close, please?" Which is the happiest Nick will ever look in his life. After this, we'll have the first speech on opposition. We'll then have the first floor round, which is where you in the audience get to have your say in the debate. We'll be taking points under a minute in proposition, opposition, and abstention of the motion. We'll then move back to the speeches, and then we'll sort of carry on in that fashion until the end of the debate, when you will all vote. One thing worth mentioning is, of course, that points of information are not just allowed, but encouraged. If you wish to interrupt a speaker at some point during their speech, please just stand up, say, "point of information," or "on that point," or "sir," or "madam," or make some form of verbal articulation which implies you wish to speak. They will then look at you disparagingly and say, "No, thank you," or "yes, please," at which point, please make a brief point probably about something they've said. That'd be great. And then sit down again. It is their time, please remember that. Okay, I think that's pretty much everything. Oh, yes, we take tweets now. Yeah, if you'd like to tweet in a point to us, We're also live streaming this, so anyone who's watching out there on the big interwebs, if you'd like to tweet to us, our handle is @CambridgeUnion, or I thought of a hashtag. We can have hashtag RTBF, which is the right to be forgotten. That's a mouthful. Please do tweet in. It makes my day a lot better. All right. So without any further ado, our first speaker on proposition is David Smith. David is the Deputy Commissioner with responsibility for the data protection at the Information Commissioner's Office. David.
Thank you, and I'm speaking in favour of the motion that we support the right to be forgotten. And I would emphasise that this is not just supporting the Court of Justice decision on search engines. The concept of right to be forgotten is much wider than that. And I've got 3 propositions to put to you: that this is not a revolutionary right, it's nothing new, and it's not just about the court judgment, that it really matters, it affects people's lives, and that whilst there are many myths around the right to be forgotten, it is a perfectly workable proposition and one which we as the regulator can bring into effect. So I say it's not just about the Court of Justice decision on Google and search engines. We've had data protection law in the UK for 30 years now, and that gives us rights to have our information accurate, kept up to date, adequate, relevant, not too much information, not excessive, not kept for longer than is necessary, and we have rights to go to organisations that keep our information and say, we want you to stop processing that information, we want you to keep it no longer. It's a limited right, but we already have that right. And it gives us some control over our information, some ability to put our past behind us. If you take credit records, if you have a court judgment, a county court judgment against you, that remains on the court record forever. It's not expunged. But from your credit reference file, which is what is checked before you go for credit, it stays there for only 6 years because of data protection rules, because of the right to be forgotten, because of the ability to put your past, your previous debts behind you and essentially reform and move on. I mean, the term right to be forgotten has become commonplace, not just because of the court judgment, but in the new EU proposals for a new data protection regime, there is a specific provision on right to be forgotten, designed not at search engines particularly, but about social media and Facebook. And the idea, which you'll all be familiar with, of people who've committed indiscretions, things that they'd rather not do, parties they'd rather not have been at, where their photograph is on Facebook, usually not put on by themselves, put on by someone else, and then it's held against them when they go for a job or whatever. The right to get that removed and to move on. And all the Court of Justice judgment on Google does is extend those provisions to search engines. Data protection law applies to controllers and processors, and because search engines have developed since the legal framework was set up, they're not covered. They escape. They're neither a controller nor a processor. The court, by a brave interpretation, and one which we would support, has brought them in within the framework of data protection law. So these principles about not keeping information too long, accurate and up-to-date, apply quite rightly to search engines as they do to every other operator in this information age. It's a natural extension of rights in search engines. All it does is bring the law up to date with where technology is. And of course, it's entirely consistent with other legal provisions. We have rehabilitation of offenders, where if you commit a criminal act, unless it's particularly serious, it is not removed, not expunged from the record, but you no longer have to declare it. And indeed, it goes into police records, which are highly confidential records, and the police officers are prosecuted regularly for misusing that information. It isn't public information, and it isn't information that should be searchable via Google. So I want to say also that this really matters to people, that lives are blighted by information appearing through search engines, information which in the past would have faded into people's memories, disappeared into newspapers' archives. But I emphasise, not erased. This isn't about erasure. This is about making information less accessible, less readily available. And much of it is trivia, where there's no right of you and I, of the population as a whole, to know the information. And as I say, it can be contrary to public policy on rehabilitation of offenders, on people moving on from their debts and credit, on preventing social exclusion, the idea that you can move out of your past and move on. And it causes damage, and it causes distress, and it causes lesser upset and embarrassment. Even David Drummond, the legal officer of Google, who opposed to the judgment, said it's hard not to emphasize with some of the cases which come before us. And let me just give you a couple of examples. Forgive me, they're drawn from the BBC. One, a victim of crime, not a criminal, a victim. Danielle, a legal secretary who was out on the night of the royal wedding with another legal secretary and was set upon by another group of girls, attacked for no reason at all, reported the matter to the police, went to A&E. The two attackers were arrested, and it turns out they live in the same street as Danielle. She moved house, she moved address, she's afraid of reprisals. For reasons of her own, she's never told her parents. She doesn't want her parents to find out about this. But every time you put Danielle's name into the search engine, up comes details of this incident in which she was a victim. And what she wants to do, and I would say she's entitled to do, is put this behind her. This is her past. She doesn't want other people reading it every time she comes across them and feeling sorry for her. Her new employer knows about it and asks questions. She doesn't want that. It appears on a racist website because the two attackers were black and Danielle is white, and she doesn't want to be associated with a racist website. She's not asking for erasure. She's just asking that every time her name is typed in, this isn't the first incident that comes up. And a criminal one. Someone who was a criminal, yes, a domestic incident, they bit the ear off their partner. I have to say, this may surprise you, it was the woman who bit the ear off the man, and the woman was convicted, her conviction was spent. If she goes for a job, she doesn't have to declare it, she can't be asked about it, but people at work Google her, they know about it, they gossip. Her boss knows about it and is sympathetic. But she doesn't know who else knows. She doesn't know what effect it has on her life. She doesn't know how many of those interviews that she was promised that she didn't get were turned down because someone searched her name and has taken against her. She's done her time, as we say. She wants a second chance. She wants compassion. She should have compassion. That conviction is hidden away. It's confidential. It's secret on the police national computer. It's not available in the public domain, other than through Google searches. And of course, children want to put their past behind them. Things that you do as a child should not be with you for the whole of your life. And things that parents do should not always be associated with children. There's another example of a famous child of a famous person, where you type the child's name in and all you come up with indiscretions of the parents. What about that child as he grows older? Should he be able to search for information about his parents, or should they have some control over what he knows about them and their past? I have to say we've done some research of our own on public perceptions, and 25% of the people say they are likely to use this right to be forgotten. That's far more than the proportion that just use their general right of access under the Data Protection Act. So I say to you, this right to be forgotten and the court judgment is working. Google have had some 200,000 requests across Europe, about 20,000 in the UK. About 50 of those they've granted. They've removed the links, the Google links. All we've had to our office so far is about 100 complaints from people who links haven't been taken down. So for some 10,000 people in the UK, it's working. They've got what they wanted. And the internet isn't broken. Life still goes on. There's no censorship here. Those who talk about erasure and censorship are just living in another world. It's not all links to media stories by any means, and it's only about searching by name. You still find the information if you search by newspaper. If it's a victim of a crime, you might find it if you search on the name of the criminal. It's when you type in David Smith, and the information which I want to put behind me and I'm entitled to, and nobody else needs to know. That's what we're talking about. That's what the right to be forgotten is. It's about accessibility and availability, not erasure. Some people criticize this because we're talking here about Google in the European Union. All of us go to Google UK, and you can go to google.com and you can type in google.com and still get the information. I'd say to you that means it's not a perfect judgment and this isn't working perfectly, but that's not the point, because 95% of the people in the UK simply go to the UK version of Google. If you really want to dig for my past, you will be able to find it, and you'd have been able to find it previously. All I'm saying is that if you just do a normal search, and you're looking at me because I'm here for this debate and you want to know about my background, the first thing that comes up shouldn't be my speeding conviction 20 years ago. That's the point that I'm making. It's about giving control to individuals, but it's limited. It doesn't apply to the artist who wanted the links to his early works removed because somehow his art had moved on and he thought these were embarrassing. It is a balancing test. It's not perfect. There are problems with the search engines, Google being the judge and jury, but it isn't revolutionary. It gives important rights to all of us. It gives some control over our information. It is workable. The search engines are not outside the law. This merely brings them within the law that applies to everybody else. And it enables us to put our past behind us. But it's not just about delisting, and it's not just about whether you support the judgment. It's about much more than that. Thank you.
Thank you very much indeed, David. Our next speaker on opposition is Julian Huppert. Julian is a fellow of Clare College, Cambridge, and has been the the Liberal Democrat MP for Cambridge since 2010. His interests include DNA databases, human rights and civil liberties, and long romantic walks on the beach. Julian.
Thank you very much for that. Years since I was first here as a new, fresh face. And it's great to follow David and to hear what he had to say. And this is not a debate about data protection. We support data protection, although I'm not sure the example that lots of police get prosecuted for going through the police records is a great way of showing how secure and safe they are. If lots of people are getting prosecuted for it, that's not as secure as it needs to be. We are here because we disagree with the court judgment that David spent most of his time talking about. It is a flawed and dangerous argument for reasons which we will outline in detail. And let me introduce the team that will show that to you. So firstly we have Gavin Hughes, who will talk about search engines, what they do, what they don't do, what they can do. We have Mariam Cook, who will talk about identity and about norms, about what this all really means. Then we have Alistair McCapra, who will talk about PR, Wikipedia, and the value of memory. But let me first set the scene, because I'm delighted that we're talking about what I think is going to be one of the biggest issues over the next decades. How do we adapt to the new digital age? Because the world is changing. Huge prevalence of digital information is revolutionising what we do and what we can do. Who would have thought 25 years ago? Not working. Who would have thought 25 years ago that I would have a small device in my pocket that could show the entirety of human knowledge, that so much of its use would be looking at cute pictures of cats? Now, the normal approach for these changes in politics, in media and society, is to ignore the tidal wave of change, then to overreact, and then to move on to the next wave. And that's why we get daft proposals to deal with this. We had the Prime Minister suggesting that when the riots happen, we should just turn off all social media. We had the last government who passed a law, which we've now suspended, to say that you could be disconnected from the internet if you download copyrighted songs 3 times. I won't ask for a show of hands. A very nervous laugh there. And the debate that we're having about the 2 possible rights to be forgotten is a symptom of a much larger and more fundamental issue. What do we do about privacy in this digital age? Because in the past it was a huge effort to collect and distribute information. The Stasi needed huge numbers of people to monitor a small number of dissidents. And those dissidents passed samizdat texts by hand to each other, an incredibly slow form of distribution. It's now completely different. Information can be copied and spread easily and instantaneously, whether by state, non-state or anti-state actors. And that's great. That's amazing. And that's dangerous. Now, most people here will have phones that can take images and videos And facial matching is really easy. So we don't need expensive spy cameras anymore. We already have them. And our phones are fantastic tracking devices. Imagine if a government asked you to carry something with you all the time that kept track of exactly where you were. You wouldn't do it. And there are lots of other examples of the changes. Jennifer Lawrence's photos, hacked from the cloud, able to spread virally in a way which could not have happened before. And it's becoming more common. Even without hacking, revenge porn is becoming far more prevalent. Intimate pictures of, say, a former girlfriend put online for all to see. Incredibly shaming, humiliating. It's led to people quitting jobs and even suicide. Now, this could not happen in the same way pre-internet. And actually, I've been running a campaign on this, and just this week, Parliament has agreed to make it illegal. So if you're thinking about doing it, don't. So how do we cope in this new age? What are the rules that need to apply? And there are 3 areas where we need to have rules. The first set is where we choose to give our information to an organisation, whether it's Facebook or Google or our NHS health records. What can they do with that data, and what rights do we have over it? And secondly, where we haven't agreed, but society has decided that our data should be made available to the police or the security services. I'm sure you all know about the Snowden revelations and how much of that is taken. What are the rules? When can people take our information against our objections? Then there's a category where nobody agreed at all, cybercrime, foreign powers espionage. Now you have to get this right. I was the MP who led the fight against Theresa May's Snoopers Charter. But I certainly don't want our security services to be the only people in the world who cannot listen into our phone calls. That would seem like a daft way to do it. So it's a really tricky issue and very important. And my party wants to bring in a digital bill of rights to capture all of this and protect us. But now let me turn to this particular issue about the right to be forgotten. Let me set out my position on it really clearly. I agree with the right to be forgotten passionately. And I disagree with the right to be forgotten passionately. Not because I'm being a typical politician, but because there are 2 very different things that are meant by it. The one I support is the idea that you should be able to demand that your information is removed from a company or organisation. That you should be able to say to Facebook, get rid of all my pictures. They're mine and not yours. That's right. That's sensible. And there may be some exceptions. If you committed a criminal offence, you can't delete the evidence and so on. But in almost every case, the power to delete is useful and sensible and gives powers to individuals, not the companies. That's the one I support. And there's a second one for a European Court of Justice judgment that says you can demand that a search engine like Google removes references to you online from their hits, even if what they're finding is true and accurate. In the specific case, the gentleman wanted Google to remove hits to a newspaper article about his home being foreclosed on. Now, I can see why he didn't want that out there. But it is true, and it seems a very perverse way to deal with it. La Vanguardia newspaper is still there. Its page is still online. The hard copies are still there. You can look at it. It's only the search engines that are tackled. And that's one of the problems with David's argument, is that search is not the same as the content. He highlighted the fact that you can look at google.com, but you can also look in almost any other way. You can look on the website of the newspaper and have a look at their internal search, and you'll find any of the information. And I don't want to see the sort of illiberal censorship where people can get important information semi-removed from the public domain because they don't really like it being there. And that's what the ruling does. It means that people can try to get rid of this information because it suits them. Now, Google do have a role in weighing the public interest in keeping the information there against the damage to the person. So serious fraud cases, for example, they might choose to leave that information up there because it's important. And that sounds fine if Google was a court. But I don't think Google have yet released their court app for everybody to use. Why should Google be the arbiters of public interest? It's not as though they want that job in any case. Now, there are already ways to ensure that content that shouldn't be in the public domain is removed. We have libel laws, for example, looked at by the judiciary, and the judiciary can decide whether information is libelous or not, and they can take steps to get it removed. And Google do, quite rightly, already filter some information out from their searches, but it's based on legality, not on the preference and arbitrary judgment from Google. Yes, they should remove images showing child sex abuse images. That's illegal, but not perfectly legal content. I have to say that applies outside this as well. And I fought very hard against Labour and Tory efforts to have internet filters, so that you have to opt in to be able to see things that somebody else may think isn't really very nice. Why should you have to opt in to see pornography or fart jokes, both of which are categories blocked by BT's filters? I don't want Google to have to make moral judgments on every website. True, legal information should not be suppressed at the search engine level. And that is why I oppose this motion. Because I support the right to be forgotten, but I don't support the right to make search engines engage in censorship. So please, oppose this motion.
Thank you very much, Julian. It's now time for our first round of floor speeches. Unfortunately, nobody has yet tweeted us. I cannot understand how this has come to pass. Please do tweet us with, insightful comments or just like fart jokes. If that's your bag, that's also fine. I'll probably read them. I'm lonely. All right. If you'd like to make a point in proposition, please put your hand up. Nobody has images on Facebook that they'd really rather weren't there. Nothing. No. God. Well, we're just going to sit here. There we go. Excellent. Get that lady a microphone. If you'd like to give your name and college, and then make your point.
Okay, Catherine Jenkinson, Jesus College. Possibly not a very good point, but it strikes me that with regards to this debate, there's quite a lot of stuff online that is sort of out of date. Like I've just Googled now, my old head teacher was accused of a crime and was cleared, and that's still basically the Daily Mail kind of took this. It's the Daily Mail, but absolutely spun it massively, basically put across a lot of false information, and that's still online despite the rule of the court. And so possibly that's something that's to bear in mind. That's the sort of thing that should be kind of hidden, that should be got rid of.
Thank
Maybe.
you. Guys, clap. Come on. There we go. It's only polite. Any points in opposition? All right, that hand went straight up. That chap there.
This one's to David Smith, I suppose. You were talking about the fact that when someone gets something taken down, it has to be judged as not in the public interest. How would you suggest Google determines whether it's in the public interest or not? Because it's not a court, as Julian said. Sorry, I'm looking at the paper. It seems to me that a corporation doesn't have the right to decide a national interest, if you understand me.
Any points in abstention? For reference, that means you neither agree nor disagree with the motion. That chap there.
Charles Story, Sydney Sussex College. I thought I'd weigh up quite heavily on opposition before I came in, but after an interesting first round of speeches, I figured I'd make a point in abstention. There's something called the Streisand effect, which came about after Barbara Streisand had something about a house and an island, and they kicked up a fuss, tried to get it down, and as a result, more searches after that occurred of the name came up rather than before. So really, from a more pragmatic point of view, to go about reducing the stuff that you don't want to see on the first page of Google, what you actually should do is just put up more stuff about yourself. So a LinkedIn profile, no, not ridiculous stuff, obviously, but a LinkedIn profile, a blog, signing up to, I don't know, a carbon capture journal or something. So you have various different societies and things, and you push down the crappy information about you to the second, third, fourth page, and then it becomes kind of a non-issue. So that's something to consider, that in terms of having google.com and do google.co.uk, by trying to get one removed from one, there are now websites that automatically track the differences between the two, and therefore create more results for the bit of information you didn't want people to see. So it's kind of counterproductive.
Excellent. Very detailed knowledge, possibly speaking from personal experience. All right, before we go back to the main debate, we have had a tweet. It only points out the fact that my socks match. Have you seen they have guinea pigs on them? Look at those, they're really cute. They're my girlfriends. Right. Let's move back to the main debate. All right. Our second speaker on proposition is John Crowcroft. John is the Marconi Professor of Communication Systems in the Computer Lab at our own wonderful University of Cambridge. John.
This is something I'd like to forget. I don't know if the camera can zoom on it. That's my Union Society membership card from 1976. The picture's quite amazing. Go on, give it a go. You got the socks. Get the picture. Focus, please. The debate could use some focus. Right. That's on Facebook. If you're not my friend, you can't see it. So, I think the right to be forgotten is an extension of a general principle of privacy. So I had a little bit of debate here about this minor legal battle. Let's think long term, because, you know, the internet's been around for, well, I've been working it since 1980, so it's been around for a while, and it's going to be around for a bit longer. Google have only been around for a short part of that period, so discussing what happens with search, or Facebook, what happens with online social networks, maybe getting a bit rat-holed in the whole debate. Privacy is really important because it oils the wheels of society. It avoids the problem of differences. We have differences of opinion. We have different views of the world. And so if you have to be exposed to all these different views all the time, there's an awful lot of toxic effect on you. The cognitive overload, the emotional problem, the baggage you had to deal with this is very, very harsh. We've seen lots of examples of this, and some stupid, not funny cartoons are published in one country and exposed to people in another country where they are offensive, genuinely, but unnecessarily exposed there. It causes death. This is not a sensible way to run the world, right? So we need to have some notion of privacy. That leads me to the notion of privacy over time. So over space, I'm not going to make a Doctor Who joke, but I could. But I won't. But I could. Don't even blink. Because the watchers are getting closer, and yeah, they are weeping angels. Over time, things change. So think about memory, human memory. We may hear about this later because we have some serious experts on both sides here. Humans do not remember things accurately. In fact, the process of recall is not replay. The process of recall is revision, is revisionary. Okay? When you recall something about a person, then your recall is also in a new context. You never step in the same river twice. It's not a stupid remark. It actually is very fundamental. So the context matters when you recall something. And so it is necessary that we think about how not only in space do we require privacy to avoid this exposure to things that don't work with our worldview, but over time when our worldview changes, we grow up or we grow older or we lose our memory, we lose our marbles. So I think there's a fundamental reason why we need to constrain in space and time where information is available. So I think this is not just a right, it's rooted in how humans work. And just because digital information is infinitely replayable and infinitely broadcastable at almost zero cost, doesn't make it magical. It doesn't escape from the inaccuracies of the original recording, the failure to capture all the context originally associated with that, or the fact that it's been replayed to somebody of whom it's no concern to anymore, but it might have been once. And so we need to build that into how the digital world works. We're in the early days, and this debate is being couched slightly in terms of a very short-term view of things just to do with this. It's triggered by, I think rightly, by a particular European Court of Justice finding, but actually we need to think about this much longer term. We need to take the long view. And how should the world work in terms of how we see things? Imagine a world where we recreate symmetry of power over information, and we've heard a little bit about this. A lot of the data protection law is about restoring power to the individual. Of course, there are things where society has a concern, where the public view of information about somebody matters. Julian is an MP. If he does something very bad, we need to know so we don't vote for him. Actually, I thought he did some very good things despite his party, and so, I think vote for him, but not in this debate. Oh, and by the way, sorry, just to cut to the chase, I completely agree about this court finding. It's stupid. It's a narrow-minded, idiotic finding. But it is rooted in a principle which we could explore properly. Okay, so imagine a world where we could control the flow of information over space and time. We had a kind of TARDIS model of open online social networks in the cloud where we could actually track where information went and revoke it. Why do you think that's impossible? You may think it's impossible. Well, hey, I'm a professor of computer science. Let me tell you, we could make that happen. Oh, yes, sorry, I will take, of course.
Excellent. Great. The microphone. Joshua Marr, Selwyn College. I don't think it is impossible, but it sounds pretty terrifying. Who decides what should and shouldn't be seen?
So this is a really good point. Absolutely. Thank you. No. and that's... To cut to the chase, that's exactly the problem, is that we cast this discussion in terms of me versus Google. Now, if you think of it in terms of my online social network, now I have around 3,000 friends on Facebook. I interact with around 150. Robin Dunbar, anthropologist at Oxford University, has Dunbar's number named after him. I did a project with him where we checked out whether online social networks behave like the real world. How am I doing for time? And so it turns out you have about the same size social network online in reality, the people you interact with. But of course it moves in time, just like your real world. You forget, people fade. That's your personal social network. If you're a slightly more public figure, look me up on Wikipedia, then there's things about you that are more public. But of course they change too, and you should have perhaps slightly more rights over those, or perhaps slightly less, depending on what the public right is. And what is the public? What is this sort of idea of the public versus me? In my online social network, it's not the public. I don't publish my Facebook information to everyone. I constrain it to a group of people. It extends a distance. I can use Google+. I have a MySpace and Orca. I have an account on Weibo. I have everything. And believe me, you can control how far this stuff goes. Why shouldn't that just be a general principle, but also over time? How about we implement forgetting as a technical solution that just like when you haven't seen somebody for a few years, you don't think of them every day. It's actually toxic to have to think of everyone every day. Think about the story by Jorge Luis Borges. Anyone know what story I'm talking about? Funes and Memorias. It's in Labyrinth. If you haven't read Labyrinth, you shouldn't be in Cambridge. Okay, so it's a great story about somebody who remembers everything. Read Delete, which is an excellent book about why we should have forgetting. Technology for forgetting could mimic the analog process in the human brain. We don't delete things in memory, we don't recall them every day, and as we don't refresh the relationship with people, we recall them less. The technology could support that, and it could support it in relation to how public our figure was. So if we have committed a massive criminal offence and we're trying to stand for the next Prime Minister of FUBAR country X, then of course it's a matter of public interest that we did something terribly bad. But if we did something slightly embarrassing, then it's not of any public interest. We could build that technology cheaply, efficiently, and it would be just fine. Now, it wouldn't involve legislation, actually. It's just something we should build. It wouldn't also interfere with targeted advertising and analytics that Google implement. In fact, when you look at your Facebook timeline, they already do this. We already have a filter bubble that not only operates over space, where you log in, where you are, but also over time. So it's a matter of trivia to actually do this, but with user control. So as a technologist, but with a little bit of sensitivity about people and understanding somewhat about human memory and respecting some legal rights, I think that should be embedded in how people behave, I think we should just build that. In fact, we're working on that in the computer lab in Cambridge. And if you want to come do a PhD with us, you'd be welcome to. If you're a social scientist, that's absolutely fine. Legal, we have psychologists, we have everyone, because we need to understand all of this. We can't go mucking around with just lawyers determining how things work, and a fight between some rather short-lived temporary techno-optimist company who think, oh, we can do this, so we should, and a bunch of lawyers who go, well, no, you shouldn't. We should have a more refined, nuanced discussion rooted in how humans work and how the technology could support how humans work properly. Thank you.
Thank you very much, John. Why didn't you tell me you had 3,000 friends on Facebook? I would have put that in your intro. That's a real qualification. I don't have that many. All right. Oh, that went down like a lead balloon. Okay. You're meant to like dispel the tension by laughing at some point. Okay. Our second speaker on opposition is Gabriel Hughes. Gabriel has over 15 years of experience leading big data and analytics for global science and technology companies such as Google and Elsevier. Gabriel.
Well, good evening to you. First of all, just to be transparent about this, I work in technology, I work for Mendeley, and yes, until last year I was employed by Google. But tonight I'm giving you my personal opinion, all right? I'm not representing the views of Google or Mendeley or Elsevier either. So let's talk about the right to be forgotten. An absolute right to be forgotten, allowing everyone complete control over what information about them should be published online, doesn't make any sense. So there are too many politicians who fiddled expenses, not you, Julian, of course, doctors who've been sued for malpractice, bankers convicted of fraud, for that to make any sense. So if there are to be more legal powers to control what information about you is out there, then there have to be limitations in defence of freedom and speech, freedom of speech and freedom to know. So there have to be some constraints. But unfortunately, we're not talking really here about the general principle of the right to be forgotten. Despite the efforts of the other side to distance themselves from the court ruling, it's the court ruling that has really led to all the controversy and the debate, and it's the reason really why we're here now. If you were to Google the right to be forgotten now, you would discover hundreds of references to this court ruling, and that's not a cynical ploy on the behalf of Google, right? It's just because it's what has happened recently. It's happened this year. There was this court ruling in May, and it's this ruling that on this side of this debate we feel so passionately about and would like to oppose. So this is the backdrop to the debate. And what this ruling is, it's a new right for European citizens to demand that search engines remove links to online public information about them. That's what we're objecting to. And I want to look at this in its detail and explain exactly what is wrong with it. Okay? So it arose in the case of Mario Costello Gonzalez versus Google. Mr. Gonzalez is a Spanish businessman who Googled himself in 2009 and found a link to a public notice about the forced repossession and sale of his house 9 years previously in order to pay his social security debts. Now, understandably, Mr. Gonzalez would have preferred people to have the impression that he's financially reliable. After all, he's a businessman and his debts have been paid off. So he did what anyone would do. He contacted the publisher of the information, La Vanguardia, and asked them to remove the notice. They said they couldn't, as the publication of the notice was a legal requirement. It had been ordered by the Spanish Ministry of Labour and Social Affairs. So here we get to the heart of the matter. Okay, the underlying problem that Mr. Gonzalez had was nothing to do with search engines. The issue he had, the problem he had, was not with Google, and yet it was Google that was pursued and ruled against in this case, and it was clearly a flawed decision, therefore, on the part of the court. Okay? If I post an online photo of you, absolutely plastered against your wishes, your beef is not with search engines, okay? It's with me. All right? If I reveal personal facts about you in a posting on a blog, your beef is not with search engines, it's with me. And if a government ministry forces a newspaper to keep a notice about your bankruptcy online, all right, then your beef is not with Google, it's with them. Okay? What's particularly perverse about this ruling is that the search engine is obliged to remove links to the information online, while the publisher has no obligation to remove the information itself. Given the way the internet works, an approach like this is bound to fail. It will simply encourage new routes of navigation to the public information, bypassing search engines and serving only to undermine the neutrality and integrity that people expect from search. This is already happening. The Daily Telegraph is now publishing a complete list of all their articles that have been unlinked in search engines. David Jordan, the Director of Editorial Policy at the BBC, declared just last week that the BBC would like to do the same. The Guardian have been considering reposting unlinked stories in a Twitter feed. And by the way, in case you find it difficult to trawl through all those different sites, you can always go to hiddenfromgoogle.com, a site which popped up exactly 1 month after the ruling. All right, it's like a game of whack-a-mole. So, the ruling fails to provide the intended protection, and at worst, it gives people a false sense of security. Perhaps the greatest irony in this whole case is that the one thing that Mr. Gonzalez didn't want anyone to know is the one thing, well, it's the only thing, right, that anyone knows about him. And all of this was entirely predictable. Search engines are just a part of the navigational infrastructure that enables the internet to function, together with social networks, wiki pages, feeds, the hypertext link itself. This right-to-be-forgotten ruling confuses navigational linking technology with the content that it points to. I'm going to make a technical point, if I may. Websites already have complete control over whether or not search engines link to their web pages. If they do not want a page to be listed in a search engine, all they have to do is apply a simple snippet, a piece of code on their page called a no-index tag. Okay? There is also a no-snippet tag if you don't want the text link explaining what the link is. Maybe the web team at La Vanguardia should have done that. All the search engines detect these tags and comply with them. So why do we pick on the search engines? Well, I suppose Google in particular is a big company, and in the minds of many people, Google kind of is the internet, right? Except, of course, that it's not the internet. I mean, nobody seems to think it's a good idea to force Google into this big brother role as it tries to arbitrate what websites can share online. Google itself appears genuinely puzzled as they try to comply with the law in each EU territory and manually self-censor their own search index. This new right turns the neutral and automated role of a search engine on its head. And while it may be easy to go after Google because of their size, not all search engines have their resources because Google is not the only search engine. No doubt Bing, maybe Yahoo, might be able to match their efforts, but what about Ask.com or Bleco or Wolfram Alpha or DuckDuckGo or AOL or all of the sector-specific search engines like Monster.com or Business.com or Macavo.com or the meta search engines? There are a lot of search engines out there. People who want to be forgotten have a lot of search engines to go after. And as the ruling affects all of these engines, in the longer run, these new resource-intensive legal requirements are bound to hit the smaller players hardest. The higher cost could squeeze out some smaller search engines, squeeze them out of the market, and make it harder for smaller ones to actually start up. Okay? Meanwhile, publishers like the BBC and The Guardian have said they would actually prefer to directly handle requests for changes to public information themselves. Publishers can address these matters more effectively and responsibly than search engines. For example, as the BBC explained, a news story which mentions 2 figures of public interest and one other person who wants to be anonymous should really edit out the reference to that person, not remove the whole story. However, unfortunately, search engines cannot share the details of the requests they get with the publishers for reasons of data protection. Only the publisher knows the story behind the story. It is not the role of search engines to make these judgments. The central error I believe the court made was to find that search engines are data controllers of personal data posted on other websites. Now, I'm not a lawyer, clearly, but I feel on very strong ground here as none other than the EU Advocate General, Nilo Jaskinson, oh, I got his name right, advised last year that search engine providers are not data controllers. The court went against this advice since in EU data protection law, in the directive, a data controller, quotes, determines the purposes and means of the processing. And this, I think, was the precise mistake. Search engines may be purposely devised by people, but the search results themselves are not. They are discovered and organized by computer algorithms, providing a data processing service for publishers and users. It's also worth pointing out that the EU Data Protection Directive on which this judgment was based was drafted in 1990, when only 1% of Europeans were online. I don't know where this idea that the internet started in 1980 comes from, by the way. And at that time, Google founder Larry Page had not even graduated from high school. As they update this legislation, EU lawmakers should focus on abuses of privacy by unscrupulous hackers and revenge porn sites, not links in search engines. The right to be forgotten ruling was a mistake. Please let us oppose this motion.
Thank you very much, Gabriel. We're just going to do a really quick floor round now. Does anyone have any points in proposition? Ah, excellent. Maybe no floor round then. Ah, that guy. Yes, I can give you the Wi-Fi password. Listen carefully. It is, you ready? JU27E5ZZUB. Come at me. Does anyone genuinely have any points in proposition? That guy. Oh. CUS. It's called CUS. What's that password again? Ah, excellent. Oh, God. It's JU27E5ZZUB. Oh, God. I'm going to need such a stiff drink after this debate. Yeah, there we go. It's on the video. It's on the video. It's all lowercase. Go to Cambridge, they said. Get a good degree, they said. They never mentioned this. You got it? Everyone happy now? Yes? Excellent. Right. Look, she's leaving. She's been so upset by this that she's going. Right. You good? Any points in proposition? No. Great. Why don't we move back to the main debate? Sorry? Abstention. Okay, fine. Any points in opposition? No. Yes. Okay, right. Guy over there. Yes. Give him a microphone. One of them.
Shonak Chatterjee, Trinity College. I thought the example from the second speaker was really disingenuous. He talked about an offensive cartoon that's published, but the problem is it's a little thing called the American First Amendment, and that would mean that Google.com would still be publishing the same information. So I'm not sure how you're eliminating that offense. And secondly, it's not really, if we consider the actual court judgment, organizations like Facebook and Twitter are still going to be containing the same information that you're not letting Google link to. So you're not really solving the problem. Thanks.
Cool. Any points in abstention? Go on, Richard. There's one there, behind you.
Does this one
like
work?
Pantomime.
Does this one work?
It does work.
Good. Richard Parkins, Trinity College. Mr. President, I'm a bit confused. I came into this debate thinking we were going to have a debate, the right to be forgotten. Namely, as the first proposer said, the right to have out-of-date information which is no longer of real interest removed so that it doesn't embarrass you. But the opposition seem to think we're debating a particular European court ruling and whether or not it's wise. And until the proposition and the opposition, or possibly you, Mr. President, could decide what we're actually debating, I'm not going to be able to decide whether to vote for or against.
Ah, excellent. Motion bashing, my favourite. All right. Is everyone settled with the Wi-Fi password now? Are you sitting comfortably? Then let's get back to the debate. All right. Our third speaker on proposition tonight is Gavin Phillipson. Gavin is a solicitor and chair in law at Durham University. His research focuses on European and UK human rights law, particularly freedom of expression. Gavin.
Well, ladies and gentlemen, we do have a bit of a problem here because it seems that the real debate between us is not for and against the motion, but indeed what the motion means. But I certainly agree with the last speaker. It's ridiculous on the other side to pretend that the right to be forgotten is nothing more or less than a European Court of Justice judgment. The right to be forgotten was spoken about in scholarship for many, many years before this judgment, and the main part of it lies in Article 17 of a draft data protection regulation. I'd be very happy to hear. I'm not going to talk about. Google in Spain is a very small part of it. That's to do with the core of the right to be forgotten is to do with your personal data, and the two are not the same. What do I mean by personal data? I mean things like your browsing history, the list of books and films you bought or searched for on Amazon, your profile of interest from Facebook that it uses to target adverts at you, every single photo of yourself that you or someone else has put online, details of every single person you've texted, called, or emailed in the last year, the fact of your treatment perhaps for a sexually transmitted disease or for an eating disorder. This is data, this is your personal data, and this is what the right to be forgotten is really about, your right to delete data about you that is online. Of course, this is the kind of data that, as Edward Snowden revealed, is also hoovered up en masse by the world's intelligence and security agencies. So what is the right to be forgotten? It's not, as the name might suggest, something strange to do with trying to control other people's memories. It is about having some control about what the internet remembers about you, that perfect digital memory. As an anonymous commenter on The Guardian put it rather well, it's the right not to have everything that you've ever done online, all you've said, bought, looked at, searched for, posted up, had posted up about you, permanently accessible in a giant database. Conversely, to say we have no right to be forgotten is to say that you have no control over your data once it's posted online. That's wrong in law and wrong in ethics too. And I should say now, don't be bamboozled by the many examples in which the right to be forgotten would remove information that is important and relevant to some aspect of the public interest. The right to be forgotten, no one suggests it's anything other than a qualified right. So examples of information that should not be removed are not arguments against the right itself, only that there should be sensible exceptions to it for things like data for medical research or preserving public safety. It's only if you are asserting that the individual should have no ability to delete data about themselves once it's online that you are truly against the right to be forgotten. At the philosophical level, I think this really breaks down to two values. The right of the individual to control what is seen about them by others versus the commercial interests that corporations have in keeping hold of and sharing your personal data in order to profit by it. This is about your privacy, because having some control about what others see or access, how they access you, is the core of the right to privacy. On a very simple level, that's why we have lockable toilet doors. That's why we have curtains in clothes shops, so that we can control the intimate visual access that people have to us. But it's also why we have social and legal rules against unwanted access to your body, against norms against eavesdropping and phone tapping about what you can communicate confidentially to others. Most importantly for our purposes, the right to privacy means control over others accessing personal information about you. And the right to privacy is in essence the claim that it's up to the individual how much of their private sphere, including their personal information, they choose to share with others. That translates in the right to be forgotten in a right to have your personal data removed once the purpose for which you supplied it has gone. It might be said, don't you consent to the use of data online? Ask yourself, what's that consent consist of? As Paul Burnell asks, what does it amount to anything more than scrolling through pages and pages of dense legal jargon that no one even reads, let alone understands, before clicking, as we always do, OK? And note, once that largely fictional consent has been given, the data, what happens to data is often completely beyond the control of the user. As well as being used to target you with advertising, it might be sold to other companies, passed en masse to the government, as we now know, or it can be stolen, of course. Consider the hacking into iCloud of nude pictures of celebrities. Now, there's no doubt many well-meaning but misguided people who oppose the idea of the right to be forgotten, though the other side are trying to make you believe it's just about one single court ruling, which is frankly ridiculous. But the real objections to the right to be forgotten come from big data, and they talk about free speech. What they're really doing there is a colossal distortion of the values that are really at stake here. For just as when the truly noble cause of free speech and free press are prostituted by the press to justify their commodification of other people's private lives, the right, in other words, to turn their private life into a story in order to make money out of it, so the idea of free speech and the right to know is often misused to protect what is actually the commercial interests of big data, by which I mean the companies that hold it and the mass media that can mine it. And this misuse, ladies and gentlemen, reaches its apogee in the United States, where the cancer of big finance has horribly distorted the idea of free speech protected under the famous First Amendment that we've heard about. US courts have largely swallowed the idea that money is speech, and that corporations, just like human beings, have the right to free speech. This leads to the conclusion that when companies sell your personal data to each other for profit, because it's a commercially valuable commodity, that is constitutionally protected free speech. This US attitude matters. Yes?
Gary Rushton, Jesus College. You've just said that, yes, corporations can use our data, but are you suggesting that corporations are also not considered people in the United States, which would mean that they would also have the right to have their data forgotten?
I'm not an expert on US data protection law. I was talking about the attitudes of US companies to European protection.
But what I mean is...
there is, in fact, no federal data protection law in the United States.
But what I mean is, a company's data is also its data. So would it be equivalent to a person's data?
I don't know, but it's not relevant to my point, which is about protecting the privacy of individuals. I'm not concerned with the privacy of corporations. Can I carry on?
Yes.
So, this US attitude that basically selling your data amounts to free speech matters because the key players online are all giant US corporations: Facebook, Google, Microsoft, Twitter. And because they're used to seeing free use of your data as free speech, that's why they're so deeply hostile to the notion of the right to be forgotten, to any attempt, in other words, by individuals to assert their privacy and thereby curb their activities. Hence, Facebook founder Mark Zuckerberg saying privacy is no longer a social norm, or Scott McNealy, founder of another US giant, Sun Microsoft Systems, being rather blunter when he said, "You have zero privacy anyway, get over it." It's sometimes said the cleverest trick the devil ever pulled was convincing the world he didn't exist. The cleverest trick that the information corporate giants pulled was convincing some people, but I trust not this audience, that the real threat to human freedom lies in the right to be forgotten, whereas the opposite is the case. As Mayor Schoenberger has pointed out, what the right to delete, which is really what the right to be forgotten is, what it's trying to combat is the loss of control the individual faces when their information, their history, in a very real sense, their personal identity, becomes an indelible part of a mass of information usable and controllable by others. Don't let the corporate bullies hypnotize you with their bogus alarmism over free speech. The real claim against the right to be forgotten is the right of companies to profit from your personal data, and that their right to profit should override your right to control your own information. That's why you should vote for the motion tonight.
Thank you very much, Gavin. Our third speaker on opposition is Mariam Cook. Mariam is a founder and CEO of PositionDial and a former senior digital consultant at the PR firm Porter Novelli. Mariam.
Thank you. Okay, thank you. It's a real pleasure to be here today. First of all, I'd like to say that I disagree with the last speaker in terms of the dimensions we have to look at in regards to this debate. So there is the commercial consideration and there's the individual private consideration, but there's also the right of society to know about what's being said and done and misdeeds that might have occurred. And there's also the right to freedom of expression. So there's actually different dimensions. It's not just the private individual and the commercial consideration. And I think we are actually agreed in many ways on many of the issues around the ruling. What we haven't talked very much about is the solutions and what we really should do about the problems that we're all facing with regards to our identity and the risks we face as individuals in terms of what is known about us. A few maybe points from the audience have touched on the actual source of the information. And I think there's a great information scholar in the US, Lawrence Lessig, some of you may be familiar with, and he talks about the sort of the confines within which we operate, being markets, laws, norms, and code. And code could be computer code or architecture. And actually, I think one of the issues we have very much is norms. And a lot of the problems we have with regards to the information that's available online, which is very much attacking individuals in a personal way, is about the norms in our media. And very many of the cases we can talk about, we cannot find really any public interest. The idea of the freedom of the press, the idea that the press is there to serve the public interest, to hold power to account. When we're talking about these pictures of celebrities and bikinis and so on, and a particular example I wanted to mention, which is again a really tricky case, is a young woman who had severe postnatal depression and 2 children. And she had this depression for some time, and she'd gone to social services and said, I'm not coping, and there's a huge issue here, and I really need some help. And it went on for quite some time, and no help was given. And in the end, she sort of turned herself in to the social services, and they came and took the children away. And it was a really terrible situation. The children were very neglected, and there was quite a sort of headline-grabbing sort of feature of the story, which was that one of the bedrooms had sort of been turned into a toilet in the property they were in. And so this young woman was, you know, really upset, losing her children, really sort of terrible situation, a lot of mental health problems. And her children were taken away, and what she was told is if she turns her life around, if she gets counselling, if she takes medication, if she gets an education, that she would have the chance perhaps to have her children back. And so this was the case, and there was a journalist who was at the court when this young woman went in for this case of child abuse and reported on it. And this woman had done everything that had been asked of her. She'd worked very hard, gone once a week to see her children in sort of a controlled situation. And this story went into a tabloid and immediately onto a search engine. Now, there is an issue with the fact that search is ubiquitous and we can find all this information, but why on earth was this story published? In what public interest was it? How many factors were considered? And I think the reason that this ruling focuses on search is because it was an easy target. And actually, the fact of the matter is that power, whether it is at the European level, at the national level, our own politicians, maybe not the ones in the room, obviously, are just entirely beholden to the media and will not challenge the norms around which press behave very much of the time. And I think that's really the fact of the matter. And unless we can address those norms, then we're going to have all these stories in the media. And getting rid of search results is not going to solve that at all. We still will have the ability to find this in the archive. And actually, moving on to search, just for a moment, because Google's obviously very relevant to this, I think Google should not be making decisions as to what's in the public interest, nor do they want to. I do, however, think that we're living in an entirely different information ecology, and that there was a reason that libraries were public, and that is that the information we can all see and hear and access is incredibly important to us as a society. And actually search is a natural monopoly. It doesn't really make sense for us to be searching on lots and lots of different engines. What's happened is they're very good at it. I know some others were mentioned, but how many of you had heard of any of them? Essentially, Google is search, and it makes sense that it actually probably is a monopoly, and we have to look at how we regulate that. How we regulate the algorithms behind Google. It is in our interest to understand in what order information is ranked, and obviously personalisation comes into it, so we're not seeing and hearing each other in an equal way anymore because of the algorithms behind Google. So I do think there is a case for regulation of Google. I just don't think there's a case for Google regulating what's in our public interest. I'll just make one more point, really, which is in relation to identity. I think that there's been a sort of concerted effort by a lot of the media to push us, and Facebook as well, actually, into the idea that we all use our real names all the time. And we put our information out there. And that's because it makes life simple for those who essentially want to commercialise that data. But it's not in many of our interests for that to be the case. And actually, there's a real case, I think, to be made, which isn't talked about very often, which is different levels of identity, anonymity, pseudonymity, and again, educating people of all ages around the norms of when you can and should use your real name. And a lot of the media, again, talk about the fact that there's all these anonymous comments and it's all trolling and there's all this abuse online. And yes, there is some of that. But there's also a lot of that above the line from the real media. There's just as much bullying and trolling, I think, you know, in the establishment. So there is sort of below the line, so to speak. And I think essentially there's some data actually from Discus, which is the largest commenting platform in the world, and they found that the quality of comments and debate and discourse is higher from people using pseudonyms than those using real names. It's a myth that if you use your real name, you somehow massively improve the quality of debate and what's being said. And I think that's another really important area, because if you're not being identified in the first place, you don't have to worry about being forgotten. So I think that idea of identity and how we identify ourselves online is really, really important. So I oppose the motion, but I think there's a lot more to be considered around it. Thank you very much.
Thank you very much indeed, Mariam. Okay, we'll move on to our final floor round now. Just to get you started, we have a couple of tweets. Hooray. So one person says, Julian Huppert's tremendous tie and cummerbund combo is winning the debate for me. Can we get... It's purple if you can't see it. It's pretty great. Just because the right to be forgotten is in Google's hands doesn't mean it has to continue there. And then... No, nothing else useful. Sorry, guys. All right. So, do we have any points in proposition? That guy over there.
So I'm Sam Deans from Emmanuel College. The opposition have talked quite a lot about this right to know, but actually there are quite a lot of things on the internet about many of us in here that I'm sure we would consider that actually the majority of the public do not have a right to know. So there are things that I share with my friends on my Facebook feed that I don't actually want the majority of people to know about. So that doesn't actually constitute a right, and it's not enough just to say that something is a right and to assume that it therefore trumps other rights. I think that my right to manage what I have about myself as an individual actually trumps the right of the society in a lot of cases. And the reason for that is because it has a greater effect on me than it does on the rest of you. So maybe you really, really want to know what I thought about the world when I was 14 years old. Well, I'll give you a clue, you don't, but it affects me more that people should know about these terrible things that I used to say when I was 14, that I have now exercised my right to be forgotten and removed. That it matters to you to know that. It makes no difference to you to know that, but it makes a big difference to me that people should know about that. So my argument is the right of the individual, actually in this case, because it makes such a huge difference, really trumps the right of the society. And it's not enough just to invoke the right of society to prove that it trumps. So I would challenge you to actually really address that point in some more detail. Thank you.
Any points in opposition? Bear in mind, this is your last chance to have your voice heard. Tweet now or forever hold your peace. Come on, that was good. Nobody? No points in opposition. Oh, guys. Can you? To that guy? All right, then. Go on, then.
Social media, and then you look at search last, and that it's legislation and it's a legal consideration, not the decision of the engines themselves. So if you have a problem with something you've already published, most of the social media sites actually let you delete it anyway. So that's the first point. But if it's out there to other publications, you should go to those first. And where you can't reach a conclusion, then you go to a legislative body, not a search engine.
Can I respond as well?
I mean, do we just want to do the debate over again? Do you feel you were that bad? No, okay. Given that was a point in opposition, does anyone have a point in abstention? Ideally not the one made earlier. There.
Hello. Oh, goodness, reacting to how odd my voice sounds. Sorry. No, I'm Oscar Powell. I'm from Peterhouse.
Can you speak up?
Oh, sorry. Right. I've partially lost my voice, so it might be a bit of an issue. My main problem with this debate so far is that it seems to me that either side is idealising the whole situation and question of the motion to suit them. If I think about what my sort of views on, not freedom of speech, because that often gets quite touchy to discuss, but freedom of information is. It's that, and how that should be regulated, is that, well, whilst there can't be, it's a simple impossibility and nonsense, it would be to have total, complete freedom of information. We all have secrets. We all have things that not only we wouldn't want other people to hear, but we couldn't live with if other people sort of heard and knew. And I imagine that is going to apply in this case as well, regarding the online manifestation of this. But it's also the case that there is sort of just information that needs to be known, and that if we were to regulate this too much and grant individual people too much a right to do this, everything would break down. And what I see here then is I see members of the opposition discussing this idea that a complete a complete right to be forgotten, allowing any individual, however sort of piffling their concern, a right to clamp down and sort of force under the weight of their will freedom of information would be toxic. And I think, yes, that's probably going to be the case. And then I sort of hear people like, I hear David Smith saying, raising to my mind, very obviously cherry-picked examples.
The core of your point.
That's what I'm trying to, I tend to dance around these things. What I'm saying is that all I've heard here today are people from the proposition discussing relatively cherry-picked examples, and people from the opposition discussing the danger of a total total right to be forgotten. And I think that the answer might lie somewhere in between. I imagine it probably would. And until some effort is made to concede certain ground by people on the proposition or the opposition, I don't know how useful this debate is going to be to me. I think, I don't see where things are going to get. Sorry for my relatively unlettered phrasing.
Thank you for that point/monologue. I like to imagine the reason you've lost your voice is because you were screaming "Living on a Prayer" in Cindy's last night. All right. Does anyone have any burning points in proposition? No. Okay. Let's move on to our final speeches of the main debate then. Our final speaker on proposition is Emma Carr. Emma has a strong interest in cybersecurity and crime. She's the director of Big Brother Watch, which is an NGO focusing on the protection of civil liberties. Emma.
Right, hello everyone. I'm afraid I don't know if I'm going to make this any clearer for you. I'm very sorry. My first half of my statement today is going to be how much I dislike the ruling on the right to be forgotten. My second half is going to be why I don't actually think the ruling on the right to be forgotten was about the right to be forgotten, and how it's absolutely fudged the debate and gotten us into the situation that we are in this evening. And I'm going to talk about what I believe the right to be forgotten is and why it's important and what we can do to uphold that. So we've heard various reasons about why the right to be forgotten ruling, or what I've been calling the right to rewrite history in the press, was not a good thing. I don't think Google should be the one that decides what we can see online. For a lot of people, as we've heard, Googling something is online. We all know, I use DuckDuckGo. We all know that there's a vast array of ways of finding out information, and to name drop, as I said to Eric Schmidt last week at the Google Advisory Council evidence hearing on this ruling, just because it's not on Google doesn't mean it does not exist, and that might have come as a surprise to Mr. Schmidt, but it is indeed the case. I also question the wording that was in the ruling. If it's inadequate, outdated or irrelevant, it can now be taken down. That is the case that we are now removing legal, accurate and non-defamatory content and Google are making that decision. Yes, they can go to the Information Commissioner's office, but there was already systems in place where you could go to Google, you could go to Facebook, you could go to the individual publisher and ask for that information to be taken down if you took question with that. I also question whether it's right for links to be taken down by Google without first of all notifying the publishers that is the case and allowing the publisher to make their case about why it should stay and why it is in the public interest. I think the lack of transparency that we've seen so far is very concerning. However, as I did mention at the council procedures last week, we have yet to see the Article 29 Working Group's guidance on how they should proceed with this ruling. The Article 29 Working Group is the collection of data protection authorities across Europe, so the Information Commissioner in this country. So perhaps they're going to provide some guidelines which will bring some proportionality and some transparency into this ruling. So what I'm concerned about is that we're moving away from a system of common sense on the internet. I think society as a whole, we are all adults, should be able to differentiate between somebody who's been found guilty of a crime and someone who's been found innocent, having been accused of a crime, something that took place 5, 10, 15 years ago compared to something that took place yesterday. We all change, our opinions change, our behaviour change, and I think as a society we can often make that decision for ourselves when we are Googling a colleague or a potential colleague. I think we also need to start moving towards an area of personal responsibility. Now, we have a former Big Brother Watch alumni intern in this room, and I can tell you now that anybody who applies to my organisation, I give them a thorough Googling, a thorough Facebooking, a thorough tweeting to make sure that if you're going to apply to work at a privacy campaign group, then you have privacy controls on your social media. If you don't, we have a good discussion about that in your interview, because I'm often intrigued as to why people would not put it on there. It's completely up to you whether you do or not, but I'm always interested to have that discussion with people. What I do think, though, is that there needs to be some regulation around what is posted about us on social media specifically, and that is the hub of what I think the right to be forgotten is. So if I post something online, or more importantly, if somebody posts something about me online, particularly a picture potentially that was taken of me on a night out in Newcastle, my hometown, circa 2007, when I was going through a strange goth chav phase. It was very odd. There are pictures out there. You can have a look and see if you can find them. Somebody once, when the Right to Be Forgotten ruling was first announced, somebody did Google me on Newsnight and went through all of the images. That was somewhat of a startling thing to face while I sat with my parents in my living room when they were going down all the images that you find on Google Images. But there we go. You can take a look at that. If I question whether some of those pictures should be up there, there are already procedures in place before this ruling for me to go about having them taken down if I do not think that it's in the public interest for it to be there. So where do we go from here? I do think that if we're going to start talking about the right to be forgotten in its purest form, we're going to need radical new changes to data laws, giving the individual far more control about what is posted about them online. And one of the ways potentially to achieve that is to make it a lot easier to bring civil cases between each other. So if I take issue with a friend who's posted one of those circa 2007 pictures of me, I should be able to take them to court and battle it out in a transparent legal system about whether it should be there or not. It shouldn't be for them or myself to go to Google and say, you can arbitrarily remove that link, but if you go to google.com or if you look at the original publisher, it is already there. For me, that's not the right to be forgotten. I think it's also very important when you're considering the right to be forgotten when you look at emergent technology. So I was talking at a biometric conference this morning and about facial recognition and about fingerprinting in schools. And I think the laws surrounding all of this emergent technology, the right that we have that if our fingerprint is taken at school, for us to get our lunch or to take out a library book or to register, what happens to that information? How do we know? We had a radical ruling, I think, in 2012 in the Protection of Freedoms Act, which said that if you're going to take a fingerprint of a child, you have to get written consent from the parent or guardian. However, that child now has the right to give an oral consent or say no. And if they say no, that oral no overrides the parent's written yes. I think that's a completely radical new way of looking at how we control our own personal information. And so therefore have the right to be told explicitly how they're collecting this information, who's going to have access to it, how long it's going to be retained for. Questions that I imagine not very many adults would think about asking, never mind children. I think it's also incredibly important when we're talking about the right to be forgotten to look at what's going on policy-wise in terms of social media prosecutions. The Crown Prosecution Service, who are responsible for prosecuting people if somebody has potentially taken offence to a social media post or if they believe illegality generally has taken place, has said very clearly in their guidance that if you delete the post in a timely fashion or apologise for the comments that you've made, you show remorse, then nothing will happen to you, because you can change your mind. You can express something. The amount of times that I've written a tweet, especially in response to somebody, and then I've just deleted it because I thought it's just not worth it. It's just not worth getting into it. But if I posted that, and then I suddenly got a knock on the door from the police, which happens to many teenagers around this country, then if I deleted it or if I showed remorse quickly enough, then I would be fine. And I think that's incredibly important. So again, I fear that I have not really swung it for you two gentlemen here this evening, but I think we need to be very, very clear that the right to be forgotten was not what was contained in this ruling. It's part of a much bigger philosophical argument to do with the data that is now out there about it and about how we can then control that data. So I really hope that this evening you will vote in proposition for this motion along with me.
Thank you very much, Emma. Our final speaker on opposition tonight, and indeed in the debate as a whole, is Alistair McCaffrey. Alistair is the Chief Executive of the Chartered Institute of Public Relations. Alistair.
Thank you very much. I'd like to begin by addressing the question from the floor from a few minutes ago about whether an individual's right to remove material which they no longer want to have in the public domain trumps the society's right to know. I just ask you to note that nobody on this side of the House has used the term rights to know. That's not a language that we've talked about. And I don't think any of us would want to mount a great argument on the basis of a right to know. But that's the term the question was put in. So my response to that is, if it's your Facebook feed or if it's your Twitter feed, of course you control it. Although technically I believe that when you sign up to these services, what you agree to is that none of that data actually belongs to you. It belongs to Facebook. But in practice, in most practical terms, you can delete it. But I put another case to you, which is, what if you and I had an argument on a discussion forum about something, about the death penalty, and you'd argued very vociferously for one case and I'd argued for another. And some years later, your opinions changed. You wanted to do something else in your life that was inconvenient, embarrassing, or annoying. Should you have the right to do something about it? If so, what would your rights be? Would you have the right to ask for the links to that entire discussion to be removed? Well, that obviously has an impact on me and anybody else who's taking part in that discussion. Should you have the right to have your contributions to that discussion somehow kind of filleted out or anonymized? And that's the kind of problem we're going to get into. It's not some of this big scary stuff about how every piece of data that we everywhere we go is going to be recorded and monetized. It's actually about people wanting the interaction of individuals' rights and the fact that what suits you may not suit me. I may want that to be on the record. I may want your contribution to be on the record. I may want the fact that we discussed that matter to be on the record. And simply saying that your right overrides mine or anybody else's who took part in that discussion, or indeed anybody else who might want to, in the course of their personal research in the future, go and find out about the sorts of arguments that people have made in the future, I think is quite a serious thing to say. There may be a case for it in some circumstances, but I don't think we should just allow ourselves to tumble into it. The European Court has decided that personal privacy is an important principle which must be upheld with care and sensitivity, and then it's outsourced the job to Google. The European Court has also not required publishers to take down web pages, only search engines to stop linking to them. The information is still there, but it's somewhat harder to find. So what we really have at the moment is not the rights to be forgotten. It's something more like the rights to hide behind broken links. If you believe that there is genuinely such a thing as the right to be forgotten, if you believe that's a robust and enduring legal principle, then really the status quo that we have at the moment, requiring search engines to remove links, cannot really be satisfactory because, as this point has been made, it's not that hard to gain. If you are determined to go and find out information about people, if you've got a particular hate campaign against someone, you can go and look on other search engines. You don't have to be particularly intelligent to figure out about looking at local newspaper links and other things. So the published articles themselves, and not merely the links to them, would need to be taken down if this right is to have any real effect. And if this supposed right becomes entrenched, then the scale of censorship required would be beyond anything we've ever seen. Now, I'm speaking as Chief Executive of the Chartered Institute of Public Relations, and one of the reasons I'm speaking against the right to be forgotten is because I believe it's potentially very damaging to the practice of public relations. Our Royal Charter defines public relations as the planned and sustained effort to establish and maintain goodwill and mutual understanding between an organisation and its publics. We also say that public relations is about reputation, and it's the result of what you do, what you say, and what others say about you. Fostering and maintaining goodwill and building a good reputation cannot ultimately be based on concealment of failure, denial of mistakes, or airbrushing away embarrassing or no longer relevant stories. In reputation terms, there may well be some short-term gains in trying to bury bad news, but it will always catch up with you, and your reputation is likely, in the long term, to suffer a greater dent than if you'd just been upfront about it in the first place. For the public relations profession, therefore, the right to be forgotten may have some superficial attraction, but it's ultimately a bad thing because it reduces transparency and erodes public trust. I want to give you an example, if there's time, of the Bhopal disaster. The Bhopal disaster was the world's worst industrial accident, which caused thousands of deaths and hundreds of thousands of injuries in 1984. It's an ongoing cause of controversy and embarrassment to the company Dow Chemical, most recently over its sponsorship of the 2012 London Olympics. Now, as I understand it, in the terms of the European Court ruling, the right to be forgotten only applies to natural persons and doesn't apply to companies. And there was a question from the floor somewhere about, well, can corporations exercise this right? Not yet. But even if we say that corporations, Dow Chemical can't exercise this right, there are individuals who are implicated in this story. There are people who worked for Dow Chemical, long retired, people who are no longer in public life, people who may find it embarrassing or annoying or inconvenient that they said something perhaps inadvertent in 1984 about the number of deaths or injuries or whether or not people should be compensated. There are Indian officials, many of them corrupt, many of them accepted money to bury stories, who may no longer be in public life, who may be able to argue they're now private people. They've moved on. They've got nothing to do with that anymore. So what happens if all of those people start to exercise their right to have themselves removed from the picture of what happened in Bhopal? The effect, I put it to you, is something like the internet having a series of mild strokes. Yes, the general picture is still there, but what here, there, and everywhere, little bits get knocked out, and suddenly it becomes impossible to know who did what, when, or who said what, or who was responsible for what.
If I may, the judgment does not say that you can have information deleted. It's about removing a link to your name. So if you search Bhopal, all that information about those Indian officials and others will still be there. It's only if you input them by name.
Sure.
It's not expanded.
Thank you. I understand and accept that point. That's if we're talking about the judgment. But actually, one of the comments is, one of the discussion has been here is we're not just talking about the judgment. We're talking more about, we are talking about the judgment, we're talking about this as a principle as well, and what the consequences might be if we try to put that into effect.
Second point of information, which is that the speaker is talking as if the right to be forgotten is going to be absolute, with no public interest exception. Everyone accepts that any right to be forgotten, just like the right to privacy, has exceptions for genuine public interest facts. The case that you were talking about is entirely with matter of legitimate public interest, and the right would not apply. You are erecting, sir, a straw man.
In which case, let me move on to knock down your straw man about how this is all about how people want to monetize your data. I want to begin with a declaration of interest because I'm a trustee of the charity Wikimedia UK, and we help individuals to share their knowledge on Wikipedia. Wikipedia, as you know, is not a commercial organization. It takes no advertising, and as we say, it's free and always will be. The potential of the right to be forgotten, I'm talking again about the general right and not specifically about the European ruling, potentially could have a very serious damaging effect on Wikipedia. And while my opinions this evening are my own and not the position of Wikimedia UK or the Wikimedia Foundation in the USA, you will find a number of people associated with Wikipedia who've been quite vociferous on the topic. The point's also been made that there isn't, the right to be established is not an innovation from this decision in May. and it has existed earlier in law. And so I want to mention an earlier case about the right to be forgotten in Germany in 2009, where a convicted murderer named Wolfgang Werle, who completed his sentence, obtained a German court order requiring the Wikimedia Foundation, based in the United States, to remove references to his crime and to his conviction from the English language encyclopedia. The servers for Wikipedia are in the USA, so it's US law, with its emphasis on the freedom of speech, which prevails as far as the encyclopedia is concerned. Also, the Wikimedia Foundation does not control the content of the encyclopedia. As everyone knows, the content is crowdsourced by members of the public, contributing and editing freely, constantly creating and updating the content. Therefore, unless the German court intended to pursue criminal sanctions against every individual anywhere in the world who reposted material which had been taken down, its decisions could have no practical effect. As a result, the article about Wolfgang Werle still exists on the English language Wikipedia, and the German Wikipedia carries details of the murder of which he was convicted. As far as the right to be forgotten, Wikipedia is at present as near as possible as it is to be bomb-proof, but it might possibly be otherwise. In my view, the right to hide behind broken links is an absurdity, and it's a retreat from the real challenge of the internet, that once something has been published, it is in effect all but impossible to unpublish it. And the European Court of Justice is trying to make a rope out of water. The near impossibility of forgetting confronts us with a culture shock, but we are a long way past the point where a few discrete tweaks of Google rankings can have much of an effect. If we're serious about the right to be forgotten, we're going to have to be very heavy-handed about it, because to have any serious effect, it must threaten serious sanctions against organizations and individuals all around the world. Civilization, I suggest to you, cannot be based on forgetting, and what is perhaps convenient for the individual may be ruinous for integrity and truth. So if you want to live in an airbrushed society, by all means vote for this motion, but I instead invite you to vote for memory and for freedom.
Thank you very much indeed, Alistair, and thank you to all the speakers in this debate, and indeed to you for coming. The door by which you leave this room is significant. If you leave by the right, that means you are voting aye. If you leave by the door on the left, that means you are voting no. If you leave down the middle, that means you still think the motion is a little bit silly and you are abstaining. You'll note if you are in the gallery, there are only 2 doors. Catherine up there will take your vote for you. Hooray. If you stick around in the bar, after about 5 minutes, we'll come and announce the results. It's always really interesting, so please do stay for a drink. Thank you all for coming.